Good evening, ladies and gentlemen. It is 7 o'clock and it's time for the meeting of council. As you're aware from having received the agenda, this is a special meeting of council. We called for a number of matters. You'll see on the agenda before this evening. So, having called it to order, are there any declarations of pecuniary interest on tonight's topics? Seeing none, we will now move on to the core of our agenda. And the first item is a very important item. This is a training session with the Office of the Ombudsman. I'm very pleased to see we've got good representatives from council who have introduced themselves here shortly to us. But just so that you're all aware, I believe that we are being live streamed on the internet now. So you put on your best game face here to see your chance to look good to the public. It's a very important evening for us. As you know, we've had a report recently from the Office of the Ombudsman, and I think we've all taken that to heart and are looking forward to this presentation to get some of the questions answered to make sure that our procedures are properly improved and we're in full compliance with those meetings. So without further comment, Mr. Walker, do you wish to make further remarks before we proceed?
No, Your Worship, I think the Ombudsman team has an agenda for us tonight, so I'm just going to turn it over to them for introductions and to start off the program.
Thank you very much. Thank you.
Could you please use the microphone? We have individuals who will be live on these devices.
Absolutely. Is that coming through all right? Thank you, Mayor and the Council, for having us as well. We're very grateful to be able to come up and meet with you all tonight. My name is Ian Collins. I'm an investigator with the Office of the Ontario Ombudsman and the Open Meeting Law Enforcement team. And I'm joined by my colleague, Michelle Bird, who is counsel with the office and also with the Open Meeting team. As the Mayor said, we do have a presentation for you all tonight. However, we certainly aim to make it work for all of each of you as well, and we will be happy to take questions throughout. We do hope to cover a fair bit of material as we do go through, so you may want to wait with your question, you may not. Feel free to jump in. We're happy to take them as they come. And we just wanted to say thank you for, I know you've indicated your interest in improving your open meeting, closed meeting practices, and we are always happy to assist with that, and we hope you find the presentation useful. So just by way of overview, we will be talking a little bit about the Ombudsman's role and function, what the Municipal Act says, which I suspect many of you are familiar with, how our office deals with open meeting complaints, the always popular when is the meeting a meeting, some common pitfalls we see, and then there'll be, as I say, some time for questions. So just by way of background, our office, the Ombudsman's office, was created in 1975 and functions under the Ombudsman Act. It is an independent and impartial office of the Legislative Assembly that reports directly to the Assembly. It has the authority to investigate the conduct of the administrative conduct of provincial government organizations, which number more than 500 ministries, agencies, boards, and commissions. And now with particular relevance to tonight, since January 1, 2008, the Ombudsman has also been the investigator of closed meeting complaints for municipalities that have not appointed another investigator or who have, of course, appointed our office. The Ombudsman's powers, the Ombudsman has broad powers of investigation. As part of that, it can, though rarely does, compel municipal officials to disclose any information and documents relevant to the matter under investigation. We are also authorized to inspect government premises and summons and examine officials and others under oath. Failure to comply with or obstruction of the Ombudsman is also a provincial offense. An important tenet of our investigations, which we'll talk about as we go forward, is that under the Ombudsman Act, the Ombudsman is required to keep information obtained during investigations confidential until he issues his report or recommendations. Municipalities must make the Ombudsman's final closed meeting reports available to the public, and as part of that, the consistent practices our investigations are conducted in Canada. Now, the Ombudsman's powers, he has the authority to make recommendations which a municipality can choose to accept or not. The Ombudsman, whether in the provincial or the municipal sphere, exercises the power of moral suasion to bring public attention to maladministration. Just as I said, as you can see from the slide, by way of background, our office is fairly large, has 86 employees. We receive a great number of complaints each year. With respect to the municipal complaints, in this last fiscal year, we received approximately 110 closed meeting complaints. may very well know, there were certain changes to the municipal act that took effect January 1, 2008, which of course deal with the appointment of an investigator or the ability to request an investigation of whether a municipality or local board has complied with the closed meeting procedures under the municipal act. At last count, our office was the open meeting investigator for 190 of Ontario's 444 municipalities, either, as I said earlier, through direct appointment or as a result of the municipality not appointing a different investigator. A number of municipalities have recently decided to use our services after having initially appointed their own investigator. Our website, www.ombudsman.on.ca, is updated with information concerning the investigators for various municipalities. And just since 2008, our office has dealt with over 300 complaints and inquiries from the public about the property closing.
So now I'll just talk a little bit about what the Municipal Act says. As I'm sure you're aware, all meetings of municipal councils and most local boards and committees must be open to the public. This was the case even prior to the January 1, 2008 amendments. The difference before was that if a member of the public had an issue with an improperly closed meeting, they would have to go to court to have that addressed. And now obviously they can bring their complaint to the closed meeting investigator, which is a quicker, more expedient, and less expensive process. Under the Municipal Act, local board has a very specific meaning. It excludes school boards, conservation authorities, police services boards, and public library boards. The term committee refers to any advisory or other committee, subcommittee, or similar entity of which at least 50% of the members are also members of one or more councils or local boards. And every municipality or local board is required to pass a procedure bylaw governing the calling, place, and proceedings of meetings, and which also must include notice provisions. So all meetings of councils, local boards, and committees must be open to the public unless they come within one or more of the 9 exceptions. And now we'll just go over a little bit about the exceptions and some examples that we have of reviews that we've done involving these exceptions. So the first one is security of the property. It's not an exception that we see used very often. There was one review we did in January of 2011 involving the municipality of Greater Sudbury, specifically their audit committee. In that case, they had closed a meeting under this exception, in which they were looking at a case where they thought they were possibly going to be subject to legal action, and so they felt that protection of municipal assets from legal action was a reason to go in camera under security of property. In reviewing that case, we looked at some Information and Privacy Commissioner decisions that also looked at security of property. We use the IPC decisions sometimes as a good guide for us as to what the exceptions mean. So the decision that we looked at the IPC outlined the parameters of security of the property and said that security of the property should be interpreted in accordance with its plain meaning, which is the protection of property from physical loss or damage, such as vandalism or theft, and the protection of public safety in relation to this property. So we found that in that case, protection of municipal assets from future legal action was not appropriate for that exception. The second exception listed there is personal matters. That's the exception that we see listed most often, and it's usually fairly self-explanatory. One case that we did look at that was a little bit different was involving the township of Marion-Hyman in 2010. And in that case, we just emphasized the discretionary nature of the personal matters exception. Particularly in that case, the personal information being discussed in closed session involved an individual who actually wanted the information discussed in open session. So we just emphasized if a person actually wants the information made public, that's something the council should consider. The next exception there is proposed or pending acquisition or disposition of land. Again, that's a fairly common one, and it's fairly self-explanatory. We don't see a lot of problems with the application of that exception. Just if the municipality is planning on acquiring or disposing land, it makes sense often to have that considered in closed session. With respect to the labor relations exception, again, it's not something that we see improperly applied so often. Usually it's in terms of union negotiations, collective bargaining, that sort of thing. Litigation or potential litigation. We do see this applied improperly occasionally. There was one case we looked at involving the town of Amherstburg, and that was in February 2010. And in that case, it involved the naming rights for the new complex. They entered into an agreement to name the complex after a member of the public, and subsequently wanted to back out of that agreement. At the time of the meeting, there was no actual evidence of any current or future legal proceedings. It was more of a fear that that could happen. We noted that it's our office's view that mere speculation that litigation might arise in the future is not sufficient to bring a discussion within the scope of the litigation or potential litigation exception. In considering that, we looked at the decision of RSJ Holdings and London. It's a Court of Appeal decision. And in that decision, the court says the fact that there might be or even inevitably would be litigation arising from, in that case, a bylaw, does not make the subject matter under consideration potential litigation. So it's really a case where it has to be in the litigation. With respect to advice subject to solicitor-client privilege, generally we've just said that it has to be either the solicitor present giving advice or an actual piece of advice from the solicitor being considered. One case that we looked at of another investigator, it's Douglas Wallace for the City of Ottawa. He outlined the parameters of the solicitor-client privilege exception, and he said that it must be, number one, communication between a client and his solicitor acting in professional capacity. Number two, made in relation to the seeking or receiving of legal advice. And number three, intended to be confidential. So we thought that was a good summary of how generally that exception applies. And last one that's on the slide is the matter which may be discussed in closed session under another act. Again, that's an exception that we almost never see. It's very rare. The only case that we've really looked at, again, involved the town of Amherstburg. It was a report that we released looking at meetings between January and March of 2011. In that case, it was applied in a number of meetings. And we just noted that this is a very, very narrow exception. One case, a court case that considered that again was London and RSJ Holdings. In that case, it was a Supreme Court decision. And the court considered whether this exception applied to the closure of a meeting under the Planning Act to consider an interim control bylaw. The court concluded that the city's obligation to give notice and hold a meeting under the Planning Act, a public meeting under the Municipal Act, was distinct from provisions of the Planning Act permitting the interim control bylaws to be passed without a public hearing. So basically, the only time that you can consider a matter under this exception is if there's an act that specifically says you can or must hold a closed meeting separate and apart from your obligations under the Municipal Act. The only exception that I'm aware of is the Emergency Management and Civil Protection Act actually has a section that says municipal meetings must be closed for security reasons if you're considering certain security issues. So usually you would not see this exception applied. The education and training exception is a little bit different. It was added after a lot of the other exceptions. Closed meetings can be held under this exception if two conditions are satisfied. First, they must be held for the purpose of education and training the members at the meeting, and no member can discuss or otherwise deal with the matter in any way that materially advances the decision-making of council. Also for the education and training exception, the resolution must cite a specific section of the Act, so section 239, 3.1. For all other matters, it's good practice to cite the particular section of the Act, but it's not mandatory. And on the screen, there's just a quote from the Ombudsman's report regarding the City of Oshawa. I won't read the whole quote. But basically, this quote just says that any attempt to rely on an exception has to be carefully scrutinized. It can be very easy to rely on it thinking, oh, we're learning something about a matter, therefore it's education and training. But it is a fairly narrow exception. This quote came from a report, the ABCs of Education and Training, regarding a meeting held by the City of Oshawa's Development Services Committee to hear a presentation from a local business. The Ombudsman found that the presenters had actually been lobbying behind closed doors when they began to discuss the company's future development plans and possible relocation in connection to the municipality's proposed zoning bylaws. The only mandatory exception is when considering a request under the Municipal Freedom of Information and Protection of Privacy Act. All the other exceptions are discretionary. Under this section, a meeting must be closed to the public if the subject matter relates to the consideration of a request under NFIPA. Where the municipality has the discretion to close a meeting, so under all the other exceptions, we usually say you should seriously consider whether the public would be better served by holding the meeting in open session. This is what we generally tell municipal councils: when in doubt, keep the doors open. As you probably all know, voting is not permitted generally in closed session. The exception is that if the voting is for a procedural matter or for giving directions or instructions to officers, employees, or agents of the municipality or local board. This includes straw polls or show of hands. We often get complaints that councils have taken sort of informal votes behind closed doors, and then formalized the vote in open session. We usually say that the actual voting, the actual decision making should take place in open session. Records must be kept of all resolutions, decisions, and other proceedings of meetings, whether they are closed or open, without member comment.
I'm going to be given with a little bit about how our office handles open meeting complaints. Now, unlike under the under the provincial side of things, anyone may come to our office and state that they believe a municipality has contravened the open meeting provisions of the Act. That differs from how our office handles provincial complaints or complaints about provincial services, where we are looking to see if somebody is personally affected. And generally speaking, our practice is not to disclose the identity of the complainant. As I said, investigations are conducted in private. Recently, our office has had some councillors in certain circumstances express concern about this practice because they feel that they should be entitled to, as I think one of them said, face their accuser. However, it makes sense for us to keep this information confidential. The identity of the complainant is not material to our review of whether a meeting is properly closed or not. In addition, we're sometimes contacted by people within the municipal government with concerns about closed meetings and failing to keep their identity of the complainant, whether it be a council member, a staff member, or a member of the public, could potentially have a chilling effect on having complainants come to our office. Now, we do have a lot of people come to us who are sitting as members of councils who are concerned that complaints can sometimes be made or could be made with political motivations or could have political consequences. We understand that the open meeting investigations don't happen in a vacuum and that they may have real consequences for councillors or from council as a whole. That being said, we are sensitive to that. We review each complaint on the merits when it comes in. Generally speaking, we're not looking at the motivations behind that complaint, but we have to look at the merits of each one. Though we are certainly aware that people could make vexatious complaints, and we have certainly had cases where people have been determined to be vexatious complainants. So we do emphasize to councils that we're aware of the dynamics that are in play. We do try and listen to them with a sensitive ear, but that we have the responsibility to review each complaint on its individual merits. As you may have gathered from our slides, the open meeting law enforcement team, known by the acronym OMLET, is the dedicated resource for reviewing and investigating complaints about closed meetings. When we receive a complaint, we of course first confirm whether we have the authority to investigate. If not, we refer complaints to the designated investigator. And the last year of the complaints received, 43 were referred to municipally appointed investigators. Now, consistent with our general approach to complaint resolution, both in the provincial or municipal spheres, we resolve some open meeting complaints through informal inquiries, review, and discussion. Typically, we'll contact the clerk and find out more details about the meetings that are related, get copies of any relevant documentation, including agendas, minutes, meeting notices, as well as the applicable procedure bylaw. We may also conduct, even when it's an informal review, interviews with members of council and municipal staff. For instance, those who may have attended a particular meeting or certain attendees. If our preliminary review suggests that the matter can be resolved, we generally discuss the findings with the clerk, CAO, or other relevant staff. And depending on the nature of the issue, we might also include the mayor in the discussion, and typically we follow up with a letter summarizing that discussion. We may make suggestions for improvement based on best meeting practices, and if so, we expect our findings and views will be shared publicly. Now, as you're aware, in some cases we will start a formal investigation. This can really depend on a variety of factors. It can certainly sometimes hinge on the success of informal resolution, but a lot of times it has to do more with the nature of the issues that are involved, whether there are issues of credibility that require interviewing folks, whether we're seeing a repetition of issues that perhaps we may receive repeated complaints about a certain type of concern. And the list isn't exhaustive, and there is no one factor that's determinative. Now, when we conduct interviews, they may be conducted over the phone or in person. In some cases, particularly if facts are disputed, we may summon witnesses to attend for examination under oath or affirmation. However, I think it's safe to say that that's a fairly rare practice. We do, however, seek to record interviews with consent. This is for the purposes of ensuring accuracy, a comprehensive record, and in the hopes of saving everybody time. We also have broad discretion to terminate our investigation if the office feels that further investigation isn't necessary for our concern, as I said, that a complaint might be frivolous, vexatious, or not made in good faith. We may close an investigation without issuing a formal report. As well, before a final report is issued, we will be giving the municipality an opportunity to comment on those findings and to, in accordance with the process we've established, those preliminary findings, conclusions, and recommendations are considered confidential, and the municipality's comments will, of course, be considered before any final report is issued. Now, as you may not be surprised to hear, we get lots of people who complain about the substance, sometimes of the substantive decision-making that council makes. When dealing with open meeting complaints, our jurisdiction is restricted to considering whether the municipality has complied with the open meeting requirements and its own procedure bylaw. We don't review the substance of the municipal business conducted at the meetings. We've issued 17 formal OMLET investigative reports, which are all available on our website. When we close the file informally, as I said, we usually send a letter to the municipality outlining our review and findings, and those letters we were asked that they be shared with the public. Some of them are available on our website, and we expect to be posting more in the future. In many cases, we found that a municipality's failure to comply with the open meeting requirements is the result of a simple lack of familiarity with what those municipal act provisions are. As well, in our annual report, we have summarized some certain OMLET cases, and those summaries are also available on our website. And actually, for the first time this year, we'll be releasing an OMLET annual report, which we hope to have out by the end of October. So as I'm sure the subject of our investigation told, our conclusions are based on a review of the facts and the relevant law. The Ombudsman's recommendations are targeted at ensuring any violations of the open meeting provisions do not occur and promoting best meeting practices. We have found that other open meeting investigators take a similar approach in their reports, and we certainly strive to monitor how other open meeting investigators are treating the same issues that we face during the course of complaints. Our office has also put out the Sunshine Law Handbook, which I happen to have copies here tonight if anybody needs, public members of public or council, which have been distributed to all municipalities and are also available on our website. These reflect some of the investigations we've carried out, interpretations of the law, and discuss best practices that have emerged since the Sunshine Law came into effect. The idea, of course, behind all of this is that the public should be able to witness local democracy in action, and the Ombudsman has signaled in his reports that the open meeting provisions are remedial and they will be interpreted liberally.
So our next section is, when is a meeting not a meeting? Which seems like an odd question, but it's one that we've had to put a lot of thought into. The definition of meeting in the Municipal Act is not particularly helpful because it contains the word meeting. It's a little bit circular. The Ombudsman has turned to case law, which is developed in both Canada and the US for guidance. In an April 2008 report regarding the City of Greater Sudbury, the Ombudsman considered whether an informal gathering of Sudbury councillors that took place after the council meeting was a meeting for the purpose of the open meeting provisions. This is the definition that the Ombudsman came up with, given a review of all the relevant case law. He included that to constitute a meeting under the Municipal Act, members of council or committee must come together for the purpose of exercising the power or authority of the council or the committee, for the purpose of doing the groundwork necessary to exercise that power or authority. We included this report in the slide just because it's a bit of an interesting case. It's a February of 2009 report regarding the township of Nipissing. And in that report, the Ombudsman considered a meeting conducted by Nipissing's councillors in April 2008. And that meeting took place through a series of sequential telephone calls. The mayor essentially called up the councillors one by one to ask whether they were in favor of buying a fire truck for the township. The Ombudsman found that council had acted in good faith, but he noted that the phone around meetings that the council participated in were not an appropriate method to conduct a public meeting, since by their very nature they were conducted privately. The Ombudsman cautioned that the practice should be stopped immediately. And this is the sort of complaint that we get more and more about decision-making taking place by phone or by email, and it's just something to keep in mind and be cautious of.
All right, moving on to some of the common pitfalls that we see, some of these won't be relevant to you folks, but we'll skip through them. Of course, the very important to have proper public notice. One of the common pitfalls we see is that some municipalities have outdated procedure bylaws, not reflecting new requirements such as the need for public notice of all meetings, and that the public notice provided is inadequate. Ideally, the procedural bylaw should be clear on how and when both the public and council members receive notice of meetings. You will not be surprised to hear that we encourage public notice with as much detail as possible. And of course, as much information as can be provided in the agenda. Another issue that we regularly encounter is the failure to pass a resolution to go on camera, or passing an inaccurate or incomplete resolution before going into the closed session. A resolution, of course, must be passed in public authorizing the closed session, and the resolution to go into closed session should provide a general description of the issue to be discussed in a way that maximizes the information available to the public while not undermining the reason for excluding the public. I recognize that's sort of an ongoing balancing act, but we do ask that we do look to see that as much information can be provided as is reasonable in the circumstances. And as discussed, the resolution must be passed in open session. That means an open session, however brief, must be held prior to the closed session. It is important that the resolution accurately identify all topics to be discussed in the closed session. Simply reciting the language of the act would not normally satisfy this requirement. A brief description of the issue to be discussed is generally required, and the resolution should accurately identify all the topics to be discussed in a closed session. The subjects must also properly, of course, come to one of the statutory exceptions. Now, I think we've seen people at councils become more and more sophisticated, appreciating the need to put in more and more information on that. I think perhaps at one point in time it may be easier to put it in a blanket resolution, but I think we have seen more and more people come to the awareness that you do need to deal with each issue that will be discussed in the closed session. Now, one challenge that councils often face is agenda additions. A failure to follow the procedural bylaw requirements for adding an item to the closed meeting agenda. That's something we see a fair bit, or not having a bylaw that even allows that to occur. If the bylaw allows additions to a meeting agenda on short notice, our office asks that council follow those rules before discussing the item. The Ombudsman has recommended that the authority to add items to a closed meeting agenda without prior public notice should be used sparingly and only in circumstances where an urgent need to address the matter is demonstrated and all the proper procedure requirements have been observed. Obviously, to do otherwise would largely thwart the purposes behind open meeting provisions. We also see the occasional improper use of exceptions to the open meeting requirements, discussing items that do not come within the Act's exceptions or were not identified in the resolution authorizing the closed meeting. As Michelle alluded, in some of the cases, we do certainly sometimes see municipality interpreting exceptions very broadly. Our office, as do other closed meeting investigators, take a very narrow interpretation of the exceptions, and I think that's a good thing to keep in mind as we move forward, that when you can anticipate a more narrow interpretation of the exception. And it's already discussed improper voting in closed session, including straw polls or show of hands. And that any actual decision making should take place in the open session unless it's for a procedural matter or giving direction to staff.
And number 6 of our common pitfalls is failure to record the proceedings. The Ombudsman has found that will act can cause some confusion because it says that meetings should be recorded without note or comment. Some municipalities take the view that that means minutes should be very sparse and only include resolutions that are passed. We generally think that without note or comment just refers to extraneous notes and subjective comments, and that the minutes in fact should be quite comprehensive. Up there, it should generally be included in minutes, so where the meeting took place, when the meeting started, when it adjourned, who chaired the meeting, who attended the meeting, if any participants left or if they arrived late, a detailed description of the substantive and procedural matters discussed, and any motions, including who introduced the motion and all votes taken and directions given. In our recent reports, the Ombudsman has suggested that it would be a great idea to audio record both open and closed sessions. We know it's not a common practice in Ontario for closed sessions to be recorded, but it does happen in some U.S. jurisdictions. And it was just generally, obviously keeping the audio recordings confidential for closed meetings, but it would ensure a very comprehensive record. And from our perspective, it would be a huge time saver just to be able to review those recordings rather than having to conduct I'd like to report back to the or any of the address.
Very much.
Thank you. Person around treatment today, and on that home, is going to be coming up at closed meeting from documentation. Regarding the subject, should it be sent to that counselor as well?
I would say same answer. It would be up to the council to decide what they want to do in that situation.
Oh, thank you.
And this is, I think it's fair to say, one of the issues we encounter. We have such a narrow range of jurisdiction on the closed meetings. A lot of it is left to the independent practices that are also areas of law within the industry around conflicts of interest that we unfortunately can't speak to in a way that would provide perhaps the full picture of how closed meeting practices could work in the municipality.
I'm still a little confused on how we get direction. You're saying we'll strong vote, show of hands, record a vote, obviously, that can't do, I'm not sure. So when we do vote, when we give direction, is this something that should be recorded, or what do you think about something?
Good question. And directions are an exception to votes under the municipal act. So generally, substantive votes cannot be taken. Directions to staff or votes for procedural matter are an exception. So you can take a show of hands, you can take a recorded vote for directions to staff. We would generally think that it's a good idea to have those votes recorded in your minutes, just for the sake of having a comprehensive record of what occurred.
I'd like to say practical on that for a second. Let's say we've got in camera or a closed session to discuss which of this member of the public should be appointed to this board position. So we're talking about Mary, we're talking about Fred. So we're in closed session and we've got all sorts of opinions of these two individuals, merits, problems. How do I direct staff in a neutral sense to come back and yes, we're talking first?
So, sorry, you're talking about a direction to staff, or are you talking about?
Yes, I'm in a closed session here and I want to have staff select Mary's in. How do I do that?
Well, if you're having a substantive vote to all of council agrees to choose candidate X, that could be something that might have to take place in open session. If you're saying direction to staff, that is something that's appropriate for a closed session. And we do realize that's sometimes a fine line. It's hard to know whether it's an appropriate vote for closed session.
And we have had circumstances we have had circumstances where we've had people anonymize what's being voted on in the open session where you're dealing with personal candidates. We understand you may not want to say we're choosing to vote on this person or what have you. And I think that the key point is the decision making needs to be made in the open session, recognizing that in certain circumstances it may be a discussion of an anonymized candidate for the purpose of voting. It is a bit of a dicey area.
No, just that as we said, a direction can be given in closed session, even if it's a direction on a substantive issue. The only issue that we have is when it's sort of cloaking a rather important council decision as a direction to avoid taking that in open session. So if you are giving a proper direction to staff, that's something you can do by show of hands, by a recorded vote in closed session.
I guess I'm looking for clarity. You have to realize that I think you said there's thousands of cases you can put forward. We deal quite regularly with having to choose someone amongst a group of candidates. And we will go into closed session for that discussion, candidate A, B, and C. So if I understood you correctly, we cannot choose the winning candidate, if I can phrase it like that, in closed session. Someone will have to have our discussion, stop it before we come to a conclusion, and then go into open session. Is that what I understood?
Right. And it's hard to say for sure in the abstract. We have to look at all the facts of a specific case. But if you are making a council decision, usually we would say that has to be made in open session. And as Ian said, we have seen cases where council will say, we're going to call this candidate A, this one B, this one C. We'll take the vote to open session and vote on candidate A, B, or C. And that way you protect the privacy of the individual while still making your decision making in open session.
Interesting. Councilor Platt?
Just a further one on giving direction. What about if you're involved in litigation, and so you're making there's a negotiation, sort of going on, and you're making a decision essentially about what position to take in the negotiation. How seems a very fine line to sort of direct your staff to take this position in negotiation. Like you effectively have made a decision what you're doing in direction. So how do you get around that?
Again, it is a hard question. It's a hard one to do in the abstract. We get just an infinite variety of cases that we have to decide on their individual merits. But again, if you're directing your clerk to contact a solicitor to bring forward a certain position, if you're directing your solicitor to take a certain position in negotiations, those are appropriate for a closed session, generally.
Lucille, did you want to comment on that?
Thanks, Your Worship. If I could just follow up on that, just so I'm clear. So in the case where we're negotiating, we're talking about negotiations with the union. We're having a negotiation session the next day, and we're looking for direction from the council on if it's 2% or 3%. My understanding from what I've heard so far is that if council could say, take a show of hands vote to say it's 2%, staff are directed accordingly. And in an open session, is it acceptable to say that the direction given to staff with respect to the options for negotiation be implemented?
Generally, that would be an appropriate thing to bring forward to the open session, because I understand that you can't necessarily reveal your specific negotiation strategy during the open session.
Yeah, and I think the challenge is obviously the discussion about how you're going to negotiate. I don't think that anyone desires to see the open meeting provision blow up the ability of councils to there's negotiations that need to happen and information to the public that can cause real repercussions. I think what it looks to is, and it is incredibly situation dependent, but it looks to the ultimate decision has to be made in that open session. The ultimate decision about we're entering into an agreement with the union for X and Y. If that agreement needs to be ratified in the open session, or it needs to be the decision, the classic decision making of the council has to be made in that open session. A direction on a substantial point can still be made in a closed session. They're not just strictly limited to the procedural, but the direction to staff, like Michelle was saying, if the solicitor or the negotiator or what have you, then that can properly occur in a closed session.
So Mark wants to speak again. Even I'm having trouble with it, so discussing whether it's 2%, 3%, 4%, or whatever. You use the terms both ratified and make the decision. Regrettably, it's quite different in terms of emphasis purpose. So I've had my discussion, and I hear two councillors say 2%, I hear another councillor say 3%. I've got to come out of this. I just can't say, well, staff, you try to figure out we've got to wrap this up in closed session. So at some point, I've got to come to closure and say, okay, we're going to have part of the term on straw vote because we cannot exercise our authority in closed session. Who thinks it's 2%? And I get 4 councillors who say that that's the majority. I can take that. It's just incorrect procedure.
No, and the important point is you can exercise your authority to direct staff via vote in closed session.
So you can possibly vote to say, we're directing staff to go back with a 3% increase.
As long as it's a direction.
Again, it sounds like an answer to this, but it sounds like this includes you could do everything in this fashion. We can direct them to purchase a fire truck, we can direct them to plow the roads.
And that's what we struggle with quite often, because in the beginning especially, we did see many votes taking place in closed session that should have appropriately been done in open session and were cloaked as a direction to staff, but we felt was inappropriately. So we have to look at every case on its merits. In a case where you're, for example, directing staff to contact the union with your negotiation position, we can understand why that would not be done in open session. And we can understand why you would direct your staff to go take that position. You would want that in a closed session.
And unfortunately, the statute doesn't lay out in express terms, this is what a direction to staff exactly means, and this is what, it's a substantive vote means. And I think we try and look at it, as Michelle says, from a realistic standpoint, what are the circumstances within which that direction is made? Was that one where council is, in effect, making a very substantive decision that they wish to package, if you will, as a direction to staff, or is, the circumstance you're describing, but there are very good reasons why this direction should be made in camera and why it's necessary.
Just to close my understanding, so if you're partly closed on the matter, say, labor negotiations, we can take a show of hands as to who thinks it's 3% or 2%, and then couch that or present that as an
Well, the actual vote would be, who says we should direct staff to go ahead with a 3% offer. Take the vote, and it could be a recorded vote, it doesn't have to be a straw poll or a show of hands, it could be a recorded vote for closed session.
Mr. Walker?
We should just to maybe end this, so the ultimate vote taken at council in open session would be when the agreement of understanding comes back, that both the union and staff have signed subject to council ratification. And then it's an open document with all the details included, as far as the wage increase, the benefits, etc.
I think that's what we're looking for, that classic decision-making power. And it is a case-by-case, you know, there do those circumstances where you're rated and mired as being, what is the circumstance of the direction? But that's exactly what I think it was analogous to those circumstances where there are decisions that need to be made along the way. The directions to staff that occur along the way, obviously you say 2%, they come back to 4, do you go to 3, do you not? That's discussion that could lead to another direction of staff and so on. But, you know, the ultimate decision of, you know, are we accepting this, you know, this package is one that, you know, it should be taken in the open session.
Councilor Derby?
Thank you, Mr. Mayor. I guess with the terminology that we're using tonight, there's some confusion. Straw vote, show of hands. Your presentation that said we can't do that. Then we're saying can. I think in all fairness, what the town of Midland has gone ahead and done is said that during a closed meeting, motions will be put on the floor for direction or for procedural matters in writing with a seconder, with a motion, a mover and a seconder, and then you take the vote like you normally would. And this is where I think everybody gets a little confused is normally when you take a vote, you can call show of hands. But I think the difference is, I think what you need to tell us in your discussion that you're showing is that there should be some formal motion presented, which straw votes aren't formal motions. And I think that's where people get a little confused. So we've gone to the formal motion, or written motion, and then we take a regular vote, or we take a recorded vote, depending on which way we want to go. And I guess that's my 2 cents at this point. Other than to say, because your hands are tied by your legislation, it seems to me that we need another session. But with municipal affairs, who look after that section, well, they look after the municipal act, maybe they can shed some light on some of the questions that have been raised here, so we know what their interpretation of X, Y, and Z are. Because obviously, you guys are speculating, you don't want to get outside your legislation. But they've got their legislation, and I'm sure that they can walk us down that little aisle and say, no, this is what this means, and this is what this means, according to their interpretation of the act. And therefore, that will fall in line, and we doing the right things. Right. That's my
Mr. Collins said, we got from Councilor Jeffrey. Is it appropriate and good practice that we should have written motions or maybe some standard direction in closing?
Yeah,
Absolutely.
that's something that our office would like to see. I mean, we'd like to be able to see what happened in the closed meeting ultimately, what transpired with it, you know, and that goes to the recording it as we talked to it, but it also speaks to, if there was a direction, what was it? You know, it's hard for us to answer the question of, you know, what was the nature of the direction and the circumstance, obviously, if we can't say what was the actual wording of the direction. And from our standpoint, I think, you know, how we look at it, how you vote is somewhat inconsequential as to whether there is a vote, whether it's a show of hands or, you know, we would like it to be formalized to the extent that we can say, this is what happened, this is the wording of it, this is what transpired, so that we do have to ask questions or listen to a recording and say, okay, this is what everybody voted on.
Thank you. Councilor Brown?
So I've got a couple of questions coming out of that. So for example, when we go into a closed meeting, in addition to a written motion, is it appropriate to request or require that the information that we're also being provided to vote on or consider be in writing, so that there is actually a written record of what you were actually provided in terms of this whether it was information to give direction, or whether it was background, you know, in nature of the problem, or whether it was recommendations based on, you know, a series of you know, possible contingencies. Is there some requirement that actually be in writing as to what we're given as decision makers?
I think from our standpoint, there isn't a formal requirement that be provided in writing. I mean, as we said, and sort of as we like to say as much as we can, you know, we want to know as much as we can about what happened. So from our standpoint, you know, I think one of the sources for the emanation of a recording closed meeting is, you know, like you say, sometimes people will list their information, provide information verbally. You know, of course, 7 people's recollection of what had transpired in a meeting are all going to be different, and that's fair enough given the passage of time and subjective memories and so on. You know, so I don't think there's any sort of statutory requirement that be provided in writing, certainly. But that, you know, if there's a way to record what happens, as I said, either orally or what have you, then that would be certainly information that from our standpoint is helpful. Also may help hopefully the municipality in determining going forward, you know, if you look at a decision, then why was that decision made, or what were the options that were considered? But that's up for the municipality. I think we'll figure out what they need for their purposes. But from our purposes of assessment, more is always better.
And then coming out of the meeting, like report back, did I hear you say that it may be sufficient not to report back in a contemporaneous time, that you could have a number of different opportunities where you give direction and you don't make a final decision at council until the final decision is there? Or are we required to bring that information back each time that there was a decision made on a certain issue, not necessarily, you know, what the decision was, but that if open council was ratifying somehow that direction?
I don't think. Go ahead.
We like to see a report back after every closed session, even when a decision wasn't made. But even if there's no direction given, there's no votes on procedural matters, we like to see a general report back on what was discussed as much as possible. And there might be circumstances where there's pretty much nothing you can say, and there might be circumstances where there's quite a bit. So we like to see that after every closed session.
And just back on the report back, in terms of the level of detail that's given, you know, is it enough? I mean, it's one thing to say regulation, because it's pretty obvious who the purchase are. You know, it's our own staff and but it is say a matter of litigation. You know, how would anybody know what particular litigation matter it might be? Are we required to identify anything about, you know, what it is in the nature of, you know, property and address, but, you know, without, I'm just understanding that there may be requirements to protect privacy, but at the same time, so general, nobody from the public would know.
And litigation is a good example because it's a case where it might be a very sensitive issue and there might not be anything that you can really say after your session. I have been saying what you said in the resolution. We discussed the litigation matter, no directions coming out of this discussion or something like that. But we just look at every case on its own merits and consider whether there was maybe more information that could have been given. And it's a comment that we sometimes make that a more comprehensive report back should occur.
It's not infrequent that there isn't more information that can be provided in the resolution going in camera. And I would say, just if I may, Councillor Jeffrey's comment about speaking of municipal affairs and housing and honesty, straight approach that I know from our standpoint, our office certainly brings its interpretation of the act and so on. So you know, we always welcome information, but just in terms of you understanding from our process, we look at it from an independent standpoint. You know, whatever information that obviously you can bring to you again, but just so you know that our office acts independently to review it on our own basis.
On the report back, when you say you'd like to see people report back right away, so in a public meeting where we go in camera, so we begin the public meeting, we go to go in camera, we go in camera and we have that meeting. Do we need to be reporting back into that same meeting that we left? Or is it sufficient to have the minutes be sometime later put on a future council agenda, you know, within all the minutes that may have been of meetings municipality previously?
It's different for every municipality. Ideally, it's good to have it after you reconvene into open session at the same meeting. Although we do understand that a lot of times open or closed sessions take place at the end of the meeting. Your members of the public might not stick around at the end of that meeting. It might not be helpful at that point to give a report back if there's no one there. So you might decide to do it at a future meeting as well.
As the practical case, we often have the closed meeting called just for the sake of closed meeting, and to report back into this empty chamber at 8:30, 9 o'clock at night, and say, what's the point of all this? But what has happened is that the minute has been reported back at the following next regularly scheduled meeting, so very good practice. Perhaps there's no other questions from council. I'll have a few more. Oh, sorry. There.
With regards to the litigation, potential litigation, reasons for waiting our closed meeting, you said that mere speculation that litigation may arise is not adequate. And that you said that there was a London case, that the litigation had to be imminent. Could you just clarify a little bit further what imminent means and how it was defined in the London case?
Sure. It's a good question. In that case, I'm trying to think back. There's a statutory right of appeal for a particular decision, and they felt because there was a chance that this decision could be appealed, that was litigation or potential litigation. And the court found that a mere statutory right of appeal is not sufficient to bring it within that exception. So what you would need to see is, has someone served you with notice that they're going to be bringing you into a court case? Sometimes if someone has made threats, if their lawyers contacted you, but proceedings cannot be done, that could be enough. It's really, again, on a case-by-case basis, so we wouldn't want to give you any sort of general rule. We really have to look at it on its own merits.
But it's simply that usually having some sort of disagreement with something that may sound imperfect will enter into litigation unto itself sufficient.
My next question was, I just wanted to clarify, that last category where it says some kind of other legislation that would require a closed meeting. You seem to suggest that there is really only the Emergency Management Act that has provisions that would require a closed meeting. So it would be, again, with my understanding, extremely rare to use that.
That's right. That's the only act that I'm aware of. There definitely could be others. But it would have to be a fairly specific statement in another act saying you either can hold a closed meeting or you must hold a closed meeting for X reason. Otherwise, we would probably find that the exception is properly applied.
So, for example, in our planning meetings, we will discuss things on the planning act. So are things going to the OMB considered litigation that we're allowed to have in camera meetings on?
Yes, an OMB proceeding could be litigation, potential litigation. It can be court proceedings, it can be tribunal proceedings as well.
And I have another question. You mentioned that the identified individual might actually not want to have the matter in camera. So I presume that's where somebody is actually making a complaint to your council, or maybe even a potential contractor or somebody, or a developer. So if they request that we discuss their matter in open session, are we then to do that, or can we override that and have it in camera?
It would depend on the situation. You could still decide to exercise your discretion to take that in camera. Our question would be whether you should be exercising your discretion to take that in camera, because the purpose behind that exception is to protect individual privacy generally. So that individual is not concerned with their private matters being discussed in open session. It might be a case where it's appropriate to discuss it in open session.
But there may also be overlapping exceptions sometimes if you're going to meet with vice versa. For example, or if you're in a situation of threatened litigation with an individual, then they may, of course, be happy to have you discuss their name in public session. You may, there may be interaction with one on camera.
And just, but presumably, I was just gonna, if they're making a complaint about somebody else, their wish for it to be discussed in public would override the obligation to protect the other person's privacy.
That's correct.
Or the ability to use the exception.
Just a couple that I've been making note of here. In the interest of provide direction to staff. That's something we're looking at. When it comes to first of all, public notice, right now it's a very short statement that says we will follow the matter which is identify a person. And it doesn't say much more than that. You know, quite quickly you could pass that out, you could attach volumes of information about hiring practices in the community. But in your experience, what is appropriate in terms of that balance point? How much information should be provided to the public to notify them of the closed meeting?
The statement that we always use is provide as much information as you can without undermining the reason for proceeding in camera in the first place.
Which isn't to say you necessarily have a positive obligation to provide every written, document about Midland hiring practices for the last 80 years. But I think we do look at that balance. That is just to say, we want the public to know what's being discussed in an in-camera session to the extent that they realistically can, without making it pointless to go in camera. So I think there isn't necessarily your positive obligation to have handles and volumes of material to support each thing, but I think it is that balance that we look at in each instance.
So your experiential expectation would be that the more than this point form would actually be a supporting document in some form that describes the general nature.
Yeah, and that could be point form, it would just be something more than saying, discussing a personal matter about an identifiable individual, because that's just the wording of the exception under the Act. So if there's something more you could say, if you're discussing a complaint from a member of the public about a counselor, you could say discussing a complaint from a member of the public about a counselor. You don't have to say who you're discussing, who made the complaint, who the complaint about, but just a little bit more about what you're actually discussing.
Thank you, Richard. Again, just a clarification. So where we may have a motion in the past that said personal identification, the reason we're going in camera is to consider applications for committee of adjustment. So would that be sufficient?
It definitely could be. And again, you're not saying we're just considering Joe Smith's application, but you're saying we're discussing some applications.
I'm thinking into the meeting, and this is why I chair these meetings, and it's always a challenge because I have very good counselors here, and some would like to give a full background, history, individuals involved, review of town developments. At what point do you cut that off and say, sorry, that's not the subject matter? And I be honest, it's pretty difficult because you go on, listen to the content presented, but also apply the rules, and it takes a fair bit of mental concentration to do that. So I'm just sort of, again, trying to get balance, sort of interrupting the counselor at every turn, because I know what you're talking about the Labor Act, I know what you're talking about the bylaws of the town, I'm not talking about this issue. What's the balance point there?
I think that balance point is when you stray from the ultimate issue that's being discussed into a new realm, or if you think, okay, if I was to go back and at the start of this discussion, would I be putting this discussion now into a different category? Have we moved so far from that discussion of, okay, in considering candidates for X, we're talking about the background information of that board, or where that board sits in the realm of the town boards, but have we now moved into a category where we're now saying, listen, if I was writing up the agenda for this closed meeting, I would have to put that into a different category. I would put that into a different subject. I think that's a fair characterization, is to say, you've strayed that far. Now, it is very situationally dependent. There are times where, of course, you're going to need lots of information and lots of background information. I think we look to see, has there been a different substantive discussion, a different substantive item discussed? People are not always going to be at their most concise in closed meetings. We recognize that. That's fine. That's part and parcel of what council discussions are about. But it's had to move on to another subject that wasn't part of that initial resolution.
And we are very cognizant that this is a difficult decision to make on the spot while you're in camera. It's probably easier for us to come back and look at your minutes and, hindsight is 20/20, say this is the point which you should have stopped talking about it. So in reviewing these matters, it really is more of a moving forward educational discussion that we like to have versus, saying, oh, gotcha, this is where you stop talking about what you shouldn't have talked about.
Now, we've talked about how to establish direction properly in closed meetings, so I think I'm fine with that. Now, as we come out, let's assume that we're going to properly constitute a public meeting, public knows what it is able to participate. We have the minute presented. do we have to take out the directions or the decisions made in that meeting and vote on them?
Well, I'm hearing you say that you pass the direction to staff, for example, inside an in-camera meeting, and you're now coming out of closed session asking whether you have to essentially vote on that again. No, I mean, there's no obligation to vote on it. If it's properly in that closed session, you don't have to come out and sort of ratify that, if you will. You voted for it. The direction can be made in closed session. If it's properly a direction made in closed session, then that's one that that vote's been taken. It's been hopefully recorded in your closed meeting minutes or on your recording of that closed meeting, and that's that. I mean, you acknowledge that the direction to staff was made in the closed session, but you don't have to vote on that.
So the only record that the public would know of the directions established in a closed meeting that's appropriate for the public and confidential information is what we will find in the minute that's been approved. Is that correct?
Generally speaking, yeah.
Councilor, anything else? Councilor Cloud?
So just, to be clear, in terms of the timing then, if you give a direction on something that you actually want somebody to be acting on right away, potentially before those minutes come back to the council, then is that one that should get reported back in, at the very meeting that you called out, rather than waiting 2 weeks maybe for it to be the actual council meeting where the minutes would then be voted on? Or is the decision just there because it got made and it can't be in camera? There's no obligation to report it back to the public in any way. Not just to not vote on it, but not even to report it back.
Well, there's no obligation to report back in any event. That's the best practice that we and other public investigators tend to provide. It's not something that's under the act that you're required to do. And as you said, we think it's usually better to report back contemporaneously, but that would be up to your discretion as to what works best for your process.
Councilor Baker?
Thank you, Mr. Mayor. Just want to get my head around this a little bit here. If we give direction during an in-camera session and we vote on that, we're not really moving forward the business of the town. In essence, we're telling our staff, go do what you have to do with regards to this matter and come back to us with a recommendation. Let's just say it's to, sorry Brian, hire a new recreation director. There's 55 people who are in camera on it, and we're saying to our staff through a motion, go do your interview, come back to us with a recommendation. So the recommendation is going to come back, probably in camera, that we've got 5 here that are, this is who we recommend. Then would our next motion then be that staff present the recommended person in open council for a vote for us to hire them? That's the procedure I sort of get at. Because a lot of the times, we don't meet as a council to do that. We meet as committees. And committees would go through all of the stuff, i.e. we go through all the resumes and everything else, and we sit there and, I chew the fat, and see the way he answered this, and I didn't like the way he answered that. And you go through your whole session, in camera, of course, and then you come up with recommendations. And you tell the staff at that point that, let's move this forward to council. But we're moving it forward through a recommendation. Is that you come up with the final choice, or maybe the committee comes up with a final choice, but it's going to be a recommendation to council who actually does the hiring, which is the final, ultimate choice of who you're going to pick. But it's going to be recommended through, not action, but through recommendation as to here's who we pick, candidate F. And then you can use the third person's name, in essence, because you're an open council, and that's the person you want to hire. This whole case. So is that more or less the way we should be doing it?
That is a process we follow, and again, it's hard for us to say what a process is appropriate in the abstract, so I don't want to say, we're rubber stamping this on behalf of the government, that's okay. But that does sound like a process we've seen
heard the description, but it still strikes me as a slippery slope that given direction to go in effect a hiring process, I have therefore used the resources and assets of the town. So I'm exercising my authority. I can't see any other way as to what you do, what you exercise resources and assets of the towns. Again, I don't have a long legal discussion. The exercise of this, we've got to get practical because we need to run closed meetings in this community. And I don't want us all second guessing each other as to, well, did you really exercise authority or did you only give direction, which was sort of exercising authority. So I hate to sound like I'm being overly pragmatic about this, but at some point, the folks who believe we have to get on these meetings. And I don't want to have you call back every month for another meeting because, well, we didn't think that was the proper exercise of authority. We've got to be robust to do this meeting. So I think as long as we follow the procedure as we discussed here, that it goes into the written motion and direct staff, we can use the phraseology direct staff in that motion, and when it is properly reported and use best practices into an open session. We're fair to say whether we choose to call it just a motion or an actual vote. Is that a fair summary?
It's probably a fair summary. We do appreciate it. It is a slippery slope. It's a tough decision to make. If you generally just ask yourself, is this something that practically we can vote on in open session? Hopefully that will lead you to the right answer. Because there's certain things that it just doesn't make sense to take a vote in open session.
Last question, Sir Councilor Carmen.
Two little ones. Yeah, because when you were saying in the slides I wrote down, it said the actual decision must be taken in open session. And I think that's why it's a bit confusing.
Sure.
And I can see the direction being given.
That's applying to, and there's two separate things we're talking about here. We're talking about decision-making that does not fall within the exception. So there's directions to staff and procedural matters. The actual vote for those matters can be taken in closed session. On other matters, the votes that you're planning on taking in open session, we sometimes see votes being taken by show of hands or straw poll in the closed session prior, and then that vote is ratified in open session. We consider that inappropriate. If it's something that has to be voted on in open session, the vote should take place in open session.
And then last, you mentioned about an email series of emails, I guess, to obtain get to a decision. And I'm just wondering, because it happens when, say, a group wants to have a cross-country run, or they want to, have a parade or something. And the timing of their request is such that it's not going to be able to go before a council meeting. And so, is there any way that we are allowed to receive information asking how we would feel about that and return that information to the clerk without it violating the closed meeting session? Like, is there a way that notice can be given or something that, council is being asked to vote in this manner on a specific question due to the timing, and that we would be allowed to do that? I'm just wondering if there's a way in which that could be achieved without going out of closed meeting.
I think that would have to be under your short notice emergency or emergency meeting procedures, or short notice procedures would be made, because it is, again, sort of the classic sort of slippery slope of, one person's parade is one of the next person's more substantive decision and so on. And I don't think from our standpoint, there's a real distinction to be made about what the substance of the decision is, whether it's, a charity parade or something, much more substantive. You still need to be, do look for the proper procedure and the proper notice. In this case, I'm not sure who's going to have that. So I think it's again, for us, it's not a substance matter. We recognize that something that comes up, like we hope there could be a procedure that would allow that to be responsive. The act isn't particularly responsive to that. It still looks for all the same conditions to be satisfied regardless of the decision being made.
In terms of emails, I don't think this is something we've looked at in detail. The Nipissing case was a series of phone calls, and that was a very unusual case. We don't see too many of those. In that case, the actual decision was made by the telephone calls. There was no vote in council session. It was just, we made the decision by making a series of phone calls, and council carried out that decision. And that was why we found it was inappropriate. With respect to emails, I think we would usually find that if it's something that all of council shouldn't be getting together and discussing behind closed doors, it's not something you should be discussing over email either, because that is by its very nature closed to the public. So that would be our answer on that one.
Councilor Clerk, questions? Walter, Madam Clerk, I guess I don't too much for me to do any questions because this procedure is going to have to be established in part of our bylaws.
Your Worship, I think I had some questions coming in, but I think that presentation and the question and answer period that has answered that. So I think it's been a good night from that perspective. And as you said, we'll certainly try to make whatever changes we need to make to make sure that we're compliant.
Mr. Burke,
Mr. Chairman, if I may just add that I think, we also just would like to emphasize as well, our office isn't disappearing after tonight. We'll certainly be there if you have any additional questions people want to contact us about. We can't always answer every hypothetical question or, and unfortunately provide quite the level of direction that you may be seeking. But certainly if questions arise after tonight, yourselves or, members of the public are certainly welcome to contact us.
my apologies on this council meeting. Office of Public Affairs. First of all, thank you very much for attending this evening. I think we're all a lot better informed than a closed meeting. We will be seriously thinking about what you presented this evening, and I think we'll probably get back to you in the next month or two about our responses to how it's going to affect our procedures here. And if you can comment, I think it would be greatly appreciated by this council. So thank you so much for coming up here and sharing all of the good offices and the Elizabeth's office with us. And look forward to having you in it.
Thank you very much.
Thanks for having us.
We've got one last question.
I'm just going to, I didn't ask any questions about the committee because I understood that there was a further report that we would be receiving on the briefing committee issue.
We will. We're still reviewing that. We expect in the next couple of weeks we'll have the next agreement.
Mr. Collins, is a copy of your presentation available for this council?
We're happy to email a copy to Andre